Schlissel, estate planning lawyer. Today I'm going to talk to you about what's involved in preparing a will in New York. A will can be a very simple, basic estate planning document. The preparation and execution of a will in the state of New York requires very specific execution formalities. These execution formalities are so specific and detailed that it is essentially never recommended for a person to try to prepare and execute a will without the help of a lawyer. Our office's experience with wills prepared by individuals without the supervision of an attorney is that these attempts generally lead to litigation because the wills were not properly executed in conformity with New York State law. There are numerous requirements with regard to the execution of the will. To start with, it must be in writing. It needs to be executed at the end by the person making the will. In addition, there must be at least 2 attesting witnesses to the will. Neither of these witnesses should be an individual who receives any assets or benefits under the will. The individual executing the will must state and declare that this is his or her last will and testament. In addition, the individual executing the will must have testamentary capacity and be aware and understand the contents of the will. These are just some of the requirements necessary to execute a will. The deviation from any one of the will execution requirements renders a will invalid. An individual having a will that he or she believes is valid that turns out to be invalid may be worse off than if there was no will at all. In conclusion, it is important to consult with an experienced estate attorney with regard to drafting of wills and trusts. The preparation and drafting of a simple will is relatively inexpensive and can be done fairly quickly. This is Elliot Schlissel, Elder Care Attorney, signing off. notice. That is the basis for bringing a motion to dismiss the foreclosure. The 90-day notice refers to Real Properties Actions and Proceedings Law Section 1304. In any cases where banks have not submitted the 90-day notice, the attorneys for the homeowners have been successful in dismissing those foreclosure cases. This is Elliot Schlissel, foreclosure defense lawyer, signing off. I totally changed that.
Do I do it again or no?
No. Someone just walked in.
Yeah. Can I do this one?
Yes. Hello, this is Elliot Schlissel, foreclosure attorney. Today I'm going to talk to you about a summary judgment motion in Queens County that was denied. Now, a summary judgment motion is the way how most banks win their foreclosure lawsuits. In this case, HSBC claimed they had possession of the original note and a proper endorsement. They claimed they were the owner of the note. They took position that the homeowner, we got to start again.
Okay.
This is Elliot Schlissel, foreclosure attorney. Today I'm going to talk to you about a summary judgment motion. This is a case involving a judge in Queens County who had a summary judgment motion before him. HSBC was the bank, and the bank's attorneys claimed that HSBC had the proper endorsement and a copy of the note. They took the position that the homeowner was in default in making his mortgage payments. The homeowner in this case was named Murphy, and Murphy claimed the bank lacked standing to bring the lawsuit. His attorneys argued that a copy of the original note with the blank endorsement, which was annexed to the mortgage motion, were invalid. They claimed the endorsement had to be on a separate piece of paper. Judge Elliot, who was sitting in this case, found that the note was not sufficient. He found the endorsement did not significant. Strike that. It's going too fast. We've got to slow it down.
All right.